First, Act 88, in an attempt to safeguard against excessive use of strikes, mandated many impasse resolution procedures. The first, of course, was mediation, which had been part of Act 195. But in addition to mandated mediation, there was the imposition of mandated fact-finding. And fact-finding is an impasse resolution procedure that allows both parties to present their respective positions to a neutral. And the neutral would try to fashion an agreement from both of those positions in what was known as a fact-finder's report. And the fact-finder's report could be accepted or rejected by either party. It was not binding. Act 88 then added another layer to the impasse resolution procedures known as voluntary non-binding arbitration, the semantics of which still boggle the mind. The non-binding arbitration, in essence, is just another layer of fact-finding. So that from the 90th day of bargaining, the employer and the employee organization were placed into a merry-go-round of impasse procedures under Act 88 that did nothing more than delay the agreement of a contract in its finality. The ability of a school district to use Act 88 to delay contracts could, of course, be used from one year to the next, because Act 88 also has a provision which acts as a final strike prohibitive, and that is that an employee strike can only last to the point where the school district cannot remain in session for 180 days. And that is the mandated school year in Pennsylvania. So that the Department of Education under Act 88 is authorized to seek an injunction. Under Act 195, injunctions could only be sought by the employer through the court where the health, safety, or welfare of the public was at stake. In Act 88, it is narrowed to mean only that 180 days of school cannot be accomplished. So we have, under Act 88, instead of the attempt to provide effective impasse resolution which would lead to contracts, we have provisions that allow employers to stall bargaining to the point where contracts can become unresolved issues for 1, 2, 3, or more years, because there is not adequate means to exert influence over an employer to reach final contract status. Having said that, Act 88 has worked, and has worked in some respects quite adequately, because while the deck seems to be stacked against the employee, it made employee organizations become quite effective in using research, in using table tactics, and the use of public opinion mechanisms that would benefit the contractual purposes that they sought in ways that had not been used before, so that the greater sophistication level of the bargaining representatives under Act 88, I believe, act in the best interest of not only the employees but also the public. And while it has been a long process in developing these, we are now seeing more innovative approaches to solving contracts, one of which is being used more effectively than any other is time mediation, in which the Mediation Bureau puts the parties together for a 36-hour period and effectively reaches a contractual agreement by means other than the politics of power, but rather the politics of persuasion. And at the same time, the organization, PSEA, under Act 88, has seen probably its greatest increase in membership since the passage of Act 195, because now not only are all professional employees represented by PSEA, but the great majority of support staff in Pennsylvania are also organized and collectively bargain their agreements. The landscape of bargaining prior to the Act and after the passage of the Act is sort of like the difference between day and night. Prior to bargaining being legal in Pennsylvania, the atmosphere was one of, we need to improve our status, we need to do so even if it costs greatly, up to and including losing our jobs, because we have nowhere to go but up. There was a great ability to do whatever you wanted to at the table because there were no restraints. After the passage of the Act, it became more pro forma. A formal atmosphere existed and a more orderly approach. But I think, taken as a whole, that's the exercise of the way most things occur, from first experimentation until finally formula, and then an accepted practice of a relationship between parties. And that's a long explanation of the differences between bargaining under and without law.